All right, each of you will have 15 minutes to present your argument, and the appellant may reserve up to 5 minutes.
Thank you, Your Honor. May it please the court, my name is Cliff Nash. I'm here on behalf of Appellant, First Ohio Bank and Lending. I'd like to reserve 3 minutes for rebuttal, if I may.
Thank you.
Your Honor, this case really presents a pretty unique set of circumstances, which you don't come across very often. And somebody who's been practicing appellate law for a long, long time, I've never seen a situation quite like this. What we have before this court today is an appeal of a trial court's denial of a motion to decertify a class action claim. This matter had been previously certified by the Lorain County Common Pleas Court. It was taken up on appeal before this court. In the prior review of this appeal, this court applied what it viewed to be the controlling law, which governed this court's ability to review a class action appeal. And under the law, as this court articulated it, and it's an opinion, this court could not address a lot of the issues that we sought to raise in our prior appeal because this court deemed it going to the merits of the case. And this court indicated that in the context of the appeal of a class certification, it couldn't go into the merits of the case. After this court rendered its opinion and rejected our motion for reconsideration, the Ohio Supreme Court issued 2 opinions that we submit constitute changed circumstances that justify this court's review of an appeal of a denial of a decertification motion. The first case issued by the Supreme Court was Stamco. And in Stamco, the Ohio Supreme Court made it clear that in the context of a Civil Rule 23 analysis, courts can and should look at facts to the extent they impact Civil Rule 23 factors. We submit that case is relevant to this court's review of the case today because it really is inconsistent with the scope of review that this court applied previously based upon its understanding of what it was allowed to do in an appeal of a class action. The other case that we think constitutes changed circumstances is the Ohio Supreme Court's decision in Felix versus Ganley. Felix versus Ganley was a class action that was premised on a claim under the Ohio Consumer Sales Practices Act. And when the court that was a case that was certified both under, it concluded that the Civil Rule 23A circumstances were satisfied, and the court certified the class under B2 and B3. And that case was then appealed up to the Supreme Court. The facts in Felix were that an arbitration provision, an arbitration clause that was in a purchase agreement was unconscionable. And the trial court held that it was unconscionable because it failed to provide necessary information that should have been provided at the time of the parties entered into the purchase agreement. Information relating to the nature of the arbitration proceeding, information that would have advised the consumer as to the appellate rights that were available, and information that dealt with the scope and binding nature of the arbitration proceeding. And the trial court and the reviewing court of appeals held that the failure to provide the information when mandated under the arbitration provision rendered it unconscionable, and that was the basis of for the class action certification. As a matter of fact, the 8th District Court of Appeals, in affirming the certification in that case, indicated that the inclusion of incomplete, misleading arbitration clause satisfied the commonality requirement under Civil Rule 23A. The Supreme Court then reviewed that case in Felix, and what the Supreme Court said was, when you do a Rule 23 analysis, not only do you have to consider and review the 23 factors, but in a situation where a class action is certified under a statutory remedy, you also have to take into consideration the requirements of the statutory remedy. And the court said that in the context of a class action under the Ohio Consumer Sales Practices Act, there's a requirement to prove actual damages. So the court said that because that class action was brought under a statute that required proof of actual damages, that was one of the factors that had to be established in the vetting of the Civil Rule 23 process. And the court ultimately held that the plaintiff had failed to do so, and on the basis it decertified the class as certified under both B2 and B3. We think that the Felix case is germane to this court's review of the case of bar in 2 regards. One is The class action that's certified in this case, which is under 132211, similarly requires that its buyers injured by a violation. Both the trial court has acknowledged that the injury is a requirement in the statute, and the appellees have argued at the trial court that injury is also a factor in that. So the word injury in the statute means something.
Yes, and how does how are the damages calculated? Are they by a formula that can establish, same formula can establish damages class-wide, or are there individualized damages?
Damages can be calculated under this statute in two ways. There's a statutory minimum that can be awarded, or damages can be calculated based on proof of actual damages that may exceed proof of.
So you certify a class, then you have to have individual proceedings to set the damages.
That's exactly our point, Your Honor. Our point was the only way that the plaintiff was able to convince the trial court that they could satisfy the injury requirement was they argued, and the trial court agreed, that the loss of information that was mandated under the statute at issue in this case, 1322.062, it mandated what's known as a fee calculation statement. And this calculation statement was supposed to advise the consumer how the broker's fee was calculated. The trial court determined that that was inadequate. And the trial court held that because it's inadequate, the loss of information, otherwise that fee calculation, was injury. That's all they had to prove. The trial court, excuse me, Your Honor.
But in Ohio Savings Bank, the claim was that some of the notes had the incorrect interest rate, and that damages would require individual hearings to prove the actual injury. Yet the Supreme Court overruled the lower court and held that that was certifiable as a class, notwithstanding that individual damages had to be shown.
I will concede, Your Honor, that the determination as to the amount of damages does not render a class action non-certifiable.
So how do you distinguish these cases then?
Because this case is really, it is actually on all fours with the Ganley case. Because the Ganley case says, listen, if you're going to pursue a class action under this statute, which requires actual damages, you have to allege some class-wide amount of injury. It doesn't matter if it may be different, but you have to allege some class-wide, you have to prove it. And in this case, the indicia of proof that was presented and accepted by the trial court was loss of information equals injury. That's all they had to prove. And what we submit is that that cannot be sustained under Ohio law. There is no case law that substantiates the position that the failure to provide information in and of itself constitutes injury. And the case that we think is most relevant to the court's consideration of that, and we think this court is compelled to finally address that issue at this point, because that wasn't addressed before, and under Ganley, if you're going to bring a cause of action under a statute that requires injury, that's part of what you have to prove. You have to prove a class-wide injury. So really the issue before this court is, can plaintiff, for purposes of a class action, satisfy the requirement to prove injury under 1322.11 on the basis of loss of information alone? And we submit you can't. And the case that I think is most relevant to that issue is the 8th District Court of Appeals decision in the Thomas versus Jackson Hewitt case. Admittedly, that's not a case that involves 1322.11. It's a cause of action under a different Ohio consumer statute that is virtually identical to the statute in all relevant regards. That statute, like 1322.11, says a buyer injured by a violation may bring a claim if certain sections are violated. That statute, like 1322.11, provided for statutory minimum damages. That statute, like 1322.11, included a provision that dealt with the mandatory provision of information. The plaintiff in that Hewitt case argued that the court violated certain statutes, and among the sections it alleged violated was the provision of a form that didn't comply with the statute. So it's essentially on all fours with this. It's an allegation that the form was in violation, it didn't provide the information it was supposed to, the mandated information. What the 8th District held in Jackson is, it says, listen, injury by a violation means something. This isn't a strict liability statute. The mere fact that there's a violation doesn't give you a right to the cause of action. Even though there's statutory minimum damages available, you still have to prove some degree of injury. And because the plaintiff didn't allege individual injury, the action was dismissed. We submit that if you look at other cases in Ohio, cases dealing with the Ohio consumer, with an individual claim under the Ohio Consumer Sales Practices Act, and that's the Burge versus case, Showplace case that's cited in our material. That statute, like 132211, indicates that persons injured by a violation of this section, the courts had held, you got to prove injury in order to avail yourself to the remedy. Injury means something. So we come to a point in time in this case, and this has been a long, tortured history from our perspective in this case, that we have to have the courts address the underlying predicate of this class action, and that is, can the plaintiffs establish a class action on the allegation of nothing more than the fee disclosures in the form wasn't sufficient, and that therefore you didn't provide mandated information, i.e., the loss of mandated information in and of itself constitutes sufficient injury in order to pursue a claim. And on that point, I think the Felix Felix case is relevant, because again, bear in mind that the injury that was determined by the trial court and the Court of Appeals in Felix was the failure to provide information when it was due. At the time the people entered into the purchase agreement, they were supposed to be given relevant information that explained what the arbitration clause, how it operated. And what did the Supreme Court say when it finally established that you had to go through the statute and talk about that? It said, at best, these allegations are inchoate and incapable of satisfying a class action under a statute that requires proof of actual injury. So not only is Felix relevant in this case, because it indicates that this court must look at the statutory requirements of 132211 in order to pursue a class action claim. I think Felix is relevant because the underlying fact basis of what they claimed was the class-wide injury, the failure to provide information at the time it was due, is essentially identical to what the plaintiffs are arguing in this case. The failure to provide information when due.
That's when you're entering your rebuttal time.
Okay.
I'd like to take you back just for
Absolutely.
a brief moment to the final appealable order issue again.
I'm sorry?
To the final appealable order
Yes.
issue again. I'm still not quite getting why this case is different in regard to the circumstances in the case. In other words, if we take your argument as to why this is final and appealable, it seems to me that any case, if there's any change, any case coming out in regard to class certification, that it can automatically be the basis of a decertification and appeal taken in delayed proceedings.
Well, Your Honor, we submit that the Ralston case really does provide a narrow window, because in Ralston it was a situation with class certified appeal. At the time that appeal was taken, there was no right of immediate appealable class action certification. It was remanded back down. Then the trial court made a ruling, plaintiff sought to decertify, an appeal was taken. And the Ralston court said, we will allow the limited appeal in this circumstances because the argument that has been brought before this court on the basis of changed circumstances was not argued the first time around. When we argued the first appeal, we were focusing on standing, and the court indicated that it's not going to address the issue because it didn't think it could. This appeal is based on the new circumstances, the new finding of the Felix case, which expressed unequivocally that when you're pursuing a class action under a statute, not only do you have to satisfy Civil Rule 23, but you got to look at the requirements of the statute. And because the requirements of the statute requires proof of actual injury, that becomes a burden of the plaintiff has to establish in the context of the class certification process. So we think that under the Ralston limited holding, this court can avail itself to the opportunity to review this, and really equity compels it at this point in time. This is a situation.
Well, we can't really look at that for
But I understand that, Your Honor, but realize that this argument, although sought to be raised the first time around, and this court ruled on the basis of what it viewed to be controlling law, said we can't look at that, and didn't look at that issue.
Okay, thank you.
Thank you, Your Honor.
Good morning, Your Honor.
All right.
I'm Tom Fiodo with Jack Malicki. I represent the plaintiffs, the appellees, Lynn, Strickler, Keith Kress, and the certified class. This is First Ohio's fourth appeal in this case. Judge Whitmore has been on all 4 panels. Judge Carr has been on 3. Judge Schaefer, I agree with Mr. Mash. This is a unique case, and the reason it's unique is it shouldn't be appealable at all. The statute under which Mr. Mash is proceeding, 2505-02B5, provides that the initial decision to certify or not to certify is appealable. That happened 4 years ago. And as you've heard Mr. Mash plead with the court, he's seeking an exception, and the exception is narrow in Ralston. The exception in Ralston is that if there are changed circumstances in the case, the 6th district, by the way, I think 6th district precedence is before this court twice this morning already. But in Ralston, the 6th district said if there are changed circumstances in the case, they would permit the appeal. That is to say, that what permits the appeal under the Ralston exception is a change in circumstances occurring within the case. That's what Mr. Mash is not advocating that before this court. He's saying that decisions in other cases triggers the Ralston exception. It doesn't. This case, even if Ralston were good law, certainly it's not presidential. And I would submit, Your Honor, it's not even consistent with the statute.
I think what he's trying, and I don't mean to put words in his mouth, but I think he's advocating for an exception to the exception in regard to the fact that we didn't look necessarily at the standing.
That you'll just end up with serial appellants, Your Honor. I mean, the fact of the matter is, I'm going to find a case somewhere that I can argue to a trial court should entitle me to decertify a case. I'll file that motion, I'll have it denied, I'll appeal it. That can't be a rational exception, Your Honor. It certainly doesn't come within the statute, which provides that what is appealable is a decision that a case may or may not be maintained as a class action. Certainly, a denial of a motion to decertify does not determine that it may not be a class action. It considers that it continues to be a class action. The decision that this case may be maintained as a class action was made 4 years ago, in which the trial court required actual injury and was affirmed by a unanimous panel of this bench, in which actual injury was also required. Remember, there were motions to reconsider in that first appeal, and motions to certify conflicts in that first appeal. And Judge Whitmore's decision denying those motions, visit them and you'll see that actual injury is actually an element in her discussions. So, we at this point do not contend with what Felix and Stamko said. The point I'm making here is that Felix and Stamko are not changes in circumstance in this case, and cannot, even under the broader Ralston exception, trigger permissible appeal. And then Ralston is also not presidential in this court, and as I've mentioned, I do not believe it can be comported with the statute. The decision appeal in the instant action is not a final order under 2505-02B5 and should be dismissed. And in fact, you need not look much further than First Ohio's reply brief at page 2 to determine that. At page 2, First Ohio argues that the standard of review in this appeal is de novo, because, according to First Ohio, this is an appeal from a trial court's holding based on interpretations of statute. Well, that belies their whole argument that the reason they are permitted to appeal is because this is a decision that a case may be maintained as a class action. If First Ohio is appealing a decision on class certification, then it cannot at the same time advocate a standard of appeal other than abuse of discretion. If First Ohio is advocating a different standard of review, and it does in its reply brief, it cannot be, this appeal cannot be about class certification. This appeal should be dismissed for a lack of a final appealable order. Now, even if the appeal weren't dismissed, the trial court's decision denying decertification was correct and should be affirmed. Stamko is not new in this case. Stamko was argued by First Ohio in the Ohio Supreme Court. It was a premise on which those that dissented from taking the case argued should be considered. The Ohio Supreme Court considered Stamko. And Stamko stands for the proposition where the trial court must individually determine each class member's claim, certification is not appropriate. That's not this case, where the trial court has already determined liability class-wide. Remember, this is a case where where the parties agreed to determine the merits issues before class certification. So the merits issues are already decided. The trial court has already decided that First Ohio is liable for violating the statute. That actual injury is sufficient to trigger the statutory damages, Your Honor, under 132211, permitted class-wide recovery.
And what are the statutory?
The statutory damages, Your Honor, currently, and were true up through 2007, is disgorgement. That is, the broker must give back everything it received in the transaction, not just simply the brokerage fees that it received from the borrower, but also the yield spread premiums, whatever it received from the lenders. That is the 132211. Before 2007, Your Honor, it was only what the borrower paid the broker. And in fact, the trial court has decided that's how it's going to add to award fees should be shown in a merits determination.
There will
Award
be,
fees
each class member
Yeah.
will now have to come forward.
will
and-
not,
Pardon?
will not. Well, other than,
No, ultimately, what
oh,
are
well,
the?
the HUD statements will show that, Your Honor,
Oh,
absolutely.
okay.
I see what you mean.
Right.
Yes, and, but, you know, that's what Hamilton versus Ohio Savings says does not bar
What's
class
the
certification. Right? We took, this is like 4 years ago, deja vu all over again. And so, also, Felix. Felix is a CSPA case, Consumer Sales Practice Act. And as Felix itself recognized in paragraph 31, prior to Felix, for certification, you had to show actual consequential injury in a CSPA case. That's not new law. All right? So Felix is a CSPA case where actual injury requirement pre-existed Felix. And it's important to recognize that at footnote 4 in the Felix opinion, it carves out the entire area of case law that this case rests on. It specifically carved out the Spokio case and all of the case law under Article 3 of the federal system that provides that a statutorily mandated disclosure, the failure to give a statutorily mandated disclosure, is injury in fact Article 3 standing. It carved that entirely out. And that's important to remember. In Felix, the offense violated a prohibition. They inserted a clause that didn't belong. In our case, the violation that has been already found in the trial court is of a mandate to do something. Importantly, to give a disclosure. The legislature, recognizing that there was injury in fact caused by the failure to give the elements in 1322.062 as specified for the context, said that as a consequence, we're going to have a disgorgement remedy. That the legislature has found itself the injury in fact.
So what is the disgorgement?
The disgorgement is everything that the broker got. I mean, the brokerage
It's a
fees,
mechanical paperwork.
you add it all up and they write a check hopefully.
Do you have to have hearings on it?
There has to be, I would suggest, Your Honor, before the appeal was taken, we were in the midst of summary judgment proceedings on exactly that. The papers are there. And then all of a sudden we show up again here and take another 14 months out of the case, right? And you're here again and I'm here again, okay? The Jaffe case, Your Honor, we just recently submitted. It's a case out of the federal system. We decided July 15th. I brought copies too. It was, I think, faxed to the court. Jaffe's important because it explains Spokio and it explains, I believe, the premise under Article 3 standing, which is a heightened, it is not Ohio. Ohio does not have Article 3 requirements, but Ohio recognizes that Article 3 standing in the federal system equates with injury in fact. And in Jaffe, the court wrote that a statute may grant an individual a statutory right he or she would not otherwise have, the violation of which constitute an injury in fact. And that the types of harms the statute protects against are real. Let me suggest to you, he could have been writing about the Ohio Mortgage Broker Act and the mortgage loan disclosure statement on which this case turned. Because it was meant to forestall the failure to give the information. They didn't give the information that was required by statute. That's already been found as a matter of merit in the trial court. And as Jaffe wrote, whether those harms were actually realized is of no moment, because a plaintiff need not allege any additional harm beyond the violation of the statutory right. Stamco and Felix 2 are 23B3 cases. I mean, you can look at Stamco paragraph 6 and 67, Felix at paragraphs 34, 35. That's what they're determining. They're determining whether the plaintiff in that case made sufficient showing of predominance to permit certification under B3. Well, Your Honors, the trial court certified this class in addition under B1A and B2, and this court affirmed. So even if Stamco and Felix applied in the way that First Ohio argues, it wouldn't matter. We would still have the independently sufficient basis. They read the Stamco and Felix as applying to sort of vacuously to all of Rule 23 analysis. That's not what Stamco and Felix were involved in. In any case, Stamco and Felix don't bring anything new to this case because actual injury was, the case that Mr. Mash argued, Thompson versus Jackson Hewitt and Bird versus Curlisotas, we heard those 4 years ago. Look at page 29 of the Applebee's brief. He brought them up 4 years ago, he's still bringing them up. They don't apply, none of them are under the Ohio Mortgage Broker Act, they have nothing to do with statutorily mandated disclosures. Thompson, for example, is on the statute that prohibits more than 5 digits of your credit card number being displayed. None of those cases have to do with statutorily mandated disclosures on which this case turns. So, Your Honors, I close with the reminder, the Ohio Mortgage Broker Act is a remedial statute intended to protect consumers and must be liberally construed in favor of borrowers. So the 2 points I'm making this morning, Your Honor, is dismiss this case. There's no final appealable order. It doesn't come, even if Ralston was good law in this case, which it isn't, it's faulty, I think it's certainly not persuasive. Even if Ralston were good law, they don't come within the Ralston exception. There should be no exception to the exception, otherwise you're eating up the rule. And if the court does consider the issues on the merits, the trial judge was right. Neither Stamco nor Felix require decertification. There still be B1A, B2, and Felix and Stamco will apply in the manner in which First Ohio argues. Thank you very much.
Thank you, counsel.
Very briefly, Your Honor. I would also compel this court to look at Mr. Theodore's recent authority, the Jaffe case. There's one little fact that Mr. Theodore's overlooked, is that Jaffe involved a strict liability statute. The statute at issue said, failure by a mortgagee to present a certificate of discharge shall result in mortgagee being liable in the amount of. It's a strict liability statute. All you had to do in that statute was indicate a violation. And then, as a matter of fact, the Jaffe court says that statutes, such as the strict liability statute reviewed in that case, may confer Article 3 standing. We don't have a strict liability statute in this case. We've got a statute that says in order to have the ability to participate in the statutory remedy, the buyer has to be injured by the violation. The word injury must mean something. It wouldn't be in there otherwise. And we've brought this court's attention to a laundry list of Ohio case laws that have reviewed similar statutes in other consumer statutes that have said, when injury's in a statute, you've got to prove it. Your Honor, we are here today, admittedly under the Ralston limited authority, but we've got a case here where plaintiff is on the brink, if this court is not inclined to review this, of seeking to have my client disgorge every nickel it ever earned from brokering from 2002 to the point in time when it ceased operation in 2011. The only defense that we have asserted vigorously throughout this case, and we seek to have finally reviewed by this court today, is you can't participate in a remedy under 1322 unless you're injured. And the loss of information, the only evidence of injury that's ever been argued in the basis of certifying a class is the loss of information. That alone, under Ohio law, cannot establish the right to participate in a class action. That's what Felix tells us, and Stamco says that in the context of the Civil Rule 3 analysis, that's what this court has to look at. And for that reason, we respectfully submit that this court take this opportunity to finally address the central issue in this and reach a determination as to whether the plaintiffs may disgorge profits from an Ohio business from 2002 to present on the sole allegation that the fee statement wasn't compliant.
Thank you, counsel.
Thank you very much, Ron.
Thank you both for all of you for your presentation. Support. The court will take the matter under advisement.
Thank you.